So please stay in your seats. We'll be announcing the winner of the CodeX Prize 2026. And Harry Certain, if you could come up here, he will do the honors.
Hello. For those who were not here earlier, I'm Harry Certain. I'm Associate Director of Stanford's CodeX Center and Professor of Law at the University of Colorado. It is my honor to present the CodeX Prize to our very own Stanford Law Professor, Daniel Ho. But before I introduce Dan, let me say a little bit more about the CodeX Prize and Dan himself. So the CodeX Prize is given annually to an individual whose work has made noteworthy contributions to legal informatics or computational law, and that it has significant and enduring positive impact on the field. And it is harder to think of anyone who embodied that standard more completely than Professor Daniel Ho. Professor Ho is the William Benjamin Scott and Luna M. Scott Professor of Law, Professor of Political Science, and Professor of Computer Science by courtesy here at Stanford. He is also the founding director of Stanford's Reglab, one of the most important centers for serious empirical work on improving government. And what makes Professor Ho's body of work so distinctive is that he has influenced multiple research areas that now define the field. So first, Professor Ho is a giant in the area of modern empirical legal studies, helping to innovate with new methods and advancing legal scholarship that is quantitative, evidence-based, and grounded in institutional facts. Second, his work on AI in federal administrative agencies, including his work on algorithmic accountability and the administrative state, has changed the AI governance conversations to focus on practical and important questions about things like expertise, oversight, procurement, and capacity. And particular to this conversation, he's done a lot of foundational work on large language models and law, including his forthcoming work on the law of evaluations beyond benchmarks for AI governance, and legal fictions profiling legal hallucinations in large language models. And this gives us a sense for how good or bad large language models are at actually producing accurate and reliable legal analysis. So taken together, Professor Ho's work exemplifies what the CodeX Prize is meant to recognize: rigorous, durable scholarship that has genuinely shaped how we think about law and computation. So please join me in congratulating Professor Daniel Ho.
Harry, Roland, and the CodeX community, thank you so much for this honor. To receive this from a community I admire so much, it makes it all that much more meaningful. Harry asked me to make a few remarks, so I wanted to start off with a confession, which is that amongst this group, I actually feel a bit like an interloper. I didn't come to this work thinking I was going to be doing work on computational law, at least the way that I understood it. My work has been more fundamentally motivated by the failures of the legal system, and particularly those failures of administrative injustice when ordinary citizens engage with government by filing for a tax refund, an unemployment check, asylum, or veterans benefits. These characterize the vast majority of interactions between citizens and the state, and when government cannot get that interaction right, it's how public trust is lost. There's an unending amount of descriptive work that documents what ails these systems, but what really began this line of work is to try to develop, assess, and field interventions to improve this state of affairs, and that is what inevitably led me to the intersection of law and technology. And let me offer 3 brief reflections to that effect. First, computational law, broadly defined, has so much to offer to the legal system because it necessarily sits at that intersection. In Michigan, some 40,000 residents were falsely accused of fraud because of the improper translation of legal obligations into computable systems with a 93% error rate. So much can go astray when we don't get that translation right. I'm reminded here of a speech that Justice Breyer delivered at a conference for Chinese officials some 20 years ago at Yale Law School. The conference was simultaneously translated, And Justice Breyer was making a central point about the role of the Supreme Court in a federal system and the role of the states. He said something to the effect of, the Supreme Court doesn't make most of family law, Hartford does. The Supreme Court doesn't make most of criminal law, Hartford does. The Supreme Court doesn't make most of property law, Hartford does. All of the Chinese officials were dutifully nodding along, but Hartford, when simultaneously translated, sounds strikingly like Harvard in Mandarin. Here was a sitting justice of the U.S. Supreme Court lecturing Chinese officials who understood him to be saying at the Yale Law School that he didn't make most of the law, Harvard did. Many of the failures of government software come from these types of misunderstandings that can only be addressed by genuine exchange. Second, none of these, as all of you in the room recognize, are technical problems alone. In one collaboration with a federal agency, when we were building a simple form of AI assistance for a multi-billion-dollar adjudication program, one of our researchers noticed that a button on the user interface had erroneous text. We pointed this out to a team of contractors working on the system, and their response: we'll have to see whether fixing that is within our work order, and if so, schedule it as a task item to fix in around 6 weeks. Something that would take a Stanford undergraduate 5 minutes, maybe 1 minute with AI tooling to fix, was estimated to take 6 weeks. That is not purely a problem of technology. It's a problem of the procurement process, the dearth of technical talent within government, and the shadow of legacy technology that leads so many agencies to still rely on COBOL mainframe systems. It shouldn't be that way, but fixing these are not just software fixes. We need to ask who is empowered, by what rules, and do these rules still continue to make sense? And these are precisely the kinds of questions that computational law, at its best, forces us to confront. Third, to address these translation problems requires interdisciplinary work that has shaped so much of the field of computational law. Whether to treat the problem of tax evasion as a classification problem or a regression problem for IRS, for instance, might seem just like a technical problem, but it has massive consequences for vertical equity and the normative considerations of how we audit fairly amongst taxpayers. IRS will spend much more time auditing lower income individuals if it focuses just on whether there was any underreporting of income, and much more time on higher income individuals if what matters is whether underreporting was in the millions. As these systems migrate to high-risk domains, teams with insights from social science, philosophy, and law matter as much to ensuring the responsible design and navigation of these hidden value choices. In all of this work, I've been deeply grateful to an incredible team of collaborators, students, postdocs, and government partners who've worked to envision a future of responsible integration of technology that can improve law. The work of computational law is, at its heart, the work of translation between legal obligation and code, between technical possibility and human dignity, between law as it is and as it ought to be. I'm grateful to be part of a community that takes these three seriously, and I can't wait to see what we build together. Thank you so much.